Justice Committee will now come to order. Members, please register your attendance on the electronic voting device. All right, clerk, close the roll. Okay, we do have a quorum. There's several administrative announcements that I need to make. Those of you that are here for Senate Bill 536, patroned by Senator Obenchain, that bill is going to go by for the day. So if you're here to listen to that, that will go by for the day. It will not be heard today. Other bills that I need to make an announcement on, all these will be by voice votes. The motion will be to continue until 2027 under Rule 22. That is Senate Bill 369, Senate Bill 689, Senate Bill 345, and Senate Bill 376. Can I get a motion to continue those four bills?
Motion to continue.
Got a motion properly second. All in favor say aye. Aye. Opposed? Okay, those bills are continued. Let me skip over Senate Bill 622, patroned by Senator Marsden. That's the one bill that we want to hear today. Otherwise, I'm going to go ahead and go through the identical bills. This is going to be in an uncontested block. All members should have a sheet in front of them that has all these bills. I'm going to list them out. Senate Bill 158 by Senator Perry. Senate Bill 390, well, 391 will be separate because that's appropriation. Senate Bill 444 by Bagby. Senate Bill 743 by Aird. Those three bills in a block, those bills are all identical. I want to do something.
Mr. Chair?
Hang on a second.
Do we need a motion to conform House Bill, or Senate Bill 158 to House Bill 1485? No?
We do. We're going to have an amendment. Let me start over. Mr. Hatcher, will you report a substitute?
Yes, Mr. Chair, members of the subcommittee. So for Senate Bill 158, the bill is going to stay as it is, but we are going to also add the provisions of House Bill 1485 by Chairman Hope as it passed the House to the bill. So it will be a more expansive bill dealing with all the judges.
All right. Can I get a motion to adopt the substitute?
Move the substitute.
All right. Motion properly second. All in favor say aye.
Aye.
Opposed? Okay. The substitute is adopted. Can I get a motion to report Senate Bill 158 as substitute?
Move to report as substitute.
And is that a referral? No, it's not. All right. Is it a referral?
And then we can report the block.
Okay, but that doesn't go to appropriations.
No.
Oh, okay. So get a motion properly second. Any members wish to seek recognition? All right, clerk will please open a roll. Senate Bill 158.
And Senate Bill 444 and 743.
No. All right, so the full block is reported 22-0. Okay, so then we got a separate bill, 391, which that's patroned by Senator Stewart. That needs to go to appropriations. Can I get a motion to report and refer to appropriations?
Report and refer, move to report and refer to appropriations.
And a motion properly second to report and refer to appropriations, Senate Bill 391. Any questions on that bill? Clerk will please open roll. Members, please cast your votes. Okay. Clerk will open the roll. All members have voted. All right, clerk will please close the roll. Senate Bill 391 reports and refers to appropriations by a vote of 22-0. Next up is Senate bills that are similar to House bills. They're uncontested. Why don't we move to adopt all substitutes and amendments in this block? Get a motion?
So moved.
Motion properly second to approve all the substitutes and amendments. All in favor say aye. Aye. Opposed? Okay, so with those, the bills are properly before us. Senate Bill 24 by Carol Foy, Senate Bill 83 by Salim, Senate Bill 647 by Pillion, Senate Bill 748 by Locke, Senate Bill 812 by Boysko. Do any members wish to pull a bill from the block? All right, seeing none, I'm going to get a motion to report the block.
Move to report the block.
Second.
Motion properly second to report the block as amended and substitute. Clerk will please open the roll. All members have voted. All right, clerk will please close the roll. The block reports by a vote of 22-0. All right, next up are Senate bills similar to House bills, and these are contested, so we'll do these one at a time. The first is Senate Bill 62, patroned by Senator Lucas. We do have a substitute. Can I get a motion to adopt a substitute? Motion properly second to adopt a substitute on 62. All in favor say aye. Aye. Opposed? All right, the substitute is properly before us. Can I get a motion to report the substitute?
Move to report with substitute.
Motion properly second to report Senate Bill 62. Any members wish to ask questions? Okay, the clerk will please open the roll. Members, please cast your votes. All members have voted. Clerk will please close the roll. Senate Bill 62 reports with substitute by a vote of 15-7. Next up is Senate Bill 180, patroned by Senator Williams Graves. Can I get a motion to report?
Move to report.
Motion properly second to report Senate Bill 180. Any member wish to seek recognition on this bill? All right, seeing none, ask the clerk to please open the roll. All members have voted. Clerk will please close the roll. Bill reports by a vote of 22-0. Next up is Senate Bill 283, Senator Aird. Can I get a motion to report?
Move to report.
Second.
Motion properly second to report Senate Bill 283. Any members wish recognition on this bill? All right, seeing none, clerk will please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 283 reports by a vote of 15-7. Okay, I think that completes all of the identicals and similars. And why don't we turn over to Chair Watts for her subcommittee report. Chair Watts.
Thank you, Mr. Chairman. I first would move the bills, all of the amendments to the first block of bills that are uncontested.
All right, got a motion to adopt the amendments and the substitutes. All in favor say aye. Aye. Opposed? All right, those bills are adopted with the amendments and substitutes. Delegate Watts.
Thank you, Mr. Chairman. Senate Bill 106, as amended, provides a retail establishment that sells tenapine products without a prescription is subject to a civil penalty in the amount of $2,500 for first violation and a civil penalty of amount of $5,000 for a second or subsequent. The next bill is Senate Bill 111, and it provides that any person who enters or remains upon or within an emergency vehicle without permission or having been forbidden to do so by the owner or authorized operator is guilty of a Class 4 misdemeanor. Senate Bill 142 requires that civil penalty imposed for selling a retail tobacco product or hemp product intended for smoking to a person younger than 21 shall be deposited in the local treasury. Under current law, such civil penalty is paid to the state treasury. The next bill is Senate Bill 330. The substitute provides that any clerk of circuit court who provides a secure remote access to non-confidential court records shall allow both the Virginia Criminal Sentencing Commission and the Department of Corrections to enter a single subscriber agreement, respectively, to have secure remote access for multiple staff members who require secure remote access and complies with all other relevant law. The next bill in the block is Senate Bill 528. The substitute provides that in cases where the defendant has been charged with a misdemeanor offense, the court may order inpatient or outpatient treatment or dismiss the charges. When a defendant is found to be incompetent, the bill permits the court to order that such defendant receive treatment to restore his competency on an outpatient or in a correctional facility or at a location determined by the appropriate community services board or behavioral health authority. It also allows that the court to order the defendant receive treatment to restore his competency on the basis in a hospital. It also allows the defendant to be evaluated to determine whether he meets the criteria for temporary detention or dismiss the misdemeanor charge and release such defendant. And the bill, finally, it requires that the court to misdemeanor charges in a competency proceeding when a defendant is charged with both misdemeanor and felony offenses. The next bill, Senate Bill 559, clarifies the venue provisions for prosecution of forgery to apply to forging public documents and banknotes and utterings. The next bill, Senate Bill 713, clarifies that where a courthouse is, where a courtroom of, clarifies that where a courtroom of a locality is located within the courthouse of a different locality, the sheriff or any deputy sheriff shall have the same police powers within and on the surrounding property of the courthouse as in his own jurisdictions, and the concurrent jurisdiction when present within or in the surrounding property of such courthouse or when traveling on his official duties. The next bill, Senate Bill 714, requires a local pretrial services officer where pretrial services officers exist to conduct a risk assessment of defendants arrested on state and local warrants who are detained in jails located in the jurisdiction served by the local pretrial services. Currently, the law only requires that the pretrial service officer interview such defendants rather than doing a full assessment. The next bill is Senate Bill 764, and it permits a trial court for any offense based on the operation of a motor vehicle or watercraft, DUI, to suspend the driver's license of a defendant when deferring disposition. The bill also allows a trial court to defer judgment for a violation and successfully complete the ASAP program, and prohibits the defendant from operating a motor vehicle not equipped with an ignition interlock. The bill excludes from its provisions those with a commercial driver's license. The next bill is Senate Bill 776. It provides that failure of a defendant to pay any fines or court costs imposed on him at the time of being placed on probation as a condition of his probation shall not by itself be deemed a breach of such probation unless the court finds, after a hearing, that defendant has willfully refused to pay or failed to pay, make sufficient bona fide efforts. The bill requires the court to dismiss any such alleged breach of probation absent any specific finding to the contrary, and clarifies that such fines and costs shall remain due until paid, and all methods of payment and collection already in place are satisfied to collect the outstanding fines. The next bill, Senate Bill 804, provides that decisions of whether to rescind or redact any portion of the annual report submitted by the JERC Commission shall be made by consensus of a majority of the chairs of the House and Senate committees for courts of justice and the ranking members of the minority party serving on such committees. The next bill then that's the last in the block of the uncontested.
All right, thank you. Any members wish to pull any of those bills from the block? All right, seeing no members seeking recognition, clerk will please open roll. Clerk will please close the roll. The block of bills reports by a vote of 20-0. Chair Watts.
Thank you, Mr. Chairman. The next group are bills that are recommended to report uncontested and refer to appropriation. I move all of the substitutes and amendments.
Got a motion to adopt the substitutes and amendments. All in favor say aye. Aye. Opposed? All right, Chair Watts. Bills
The
before
first
us.
one in the group is Senate Bill 35 that provides that if a JD&R court finds a juvenile to be delinquent, the court may, before final distribution, direct the appropriate public agency to evaluate such juvenile's mental health or disability using an interdisciplinary team approach. The next bill is Senate Bill 47, and it provides that any person who impersonates a law enforcement officer while committing or attempting to commit aggravated murder, first or second degree murder, abduction, rape, forcible sodomy, object sexual penetration, aggravated sexual battery or sexual battery, or while circumventing, bypassing, or attempting to circumvent any business, commercial building, or residence owned or leased by the Commonwealth or any agency thereof, shall be guilty of a Class 6 felony. A subsequent offense is punishable by a Class 5 felony. The next one is Senate Bill 55, which provides that every adult who is convicted of an offense prohibiting proximity to children when the offense shall be as part of his sentence to be prohibited from going for the purposes of having any contact whatsoever with children who are not in his custody within 100 feet of a playground, athletic field, or facility on the premises of a state park. A violation is a Class 6 felony. The next one is Senate Bill 261, and it creates, under the animal cruelty provisions, a Class 6 felony for any person who maliciously kills any dog or cat that is a companion animal, whether belonging to him or to another. The next bill is Senate Bill 673. This is a bill that adds definitions for electronically transmitted communication and intimate partner for the crime of stalking. The next bill is Senate Bills, and the final one in the block is Senate Bill 778, which makes it a Class 6 felony for any person 18 years of age or older to display obscene material to a minor younger than 13 years of age. Current law only prohibits the display of child pornography or grooming video or materials to a child younger than 13 by a person over 18. That is the last of the block, and I move their passage.
Okay, so we got a motion to
amended
report
and
the block
substituted.
and refer to appropriations. Any members wish to seek recognition on this or to pull a bill from the block?
Mr. Chairman,
All right, yes.
I'm sorry.
Delegate Sullivan. I'm sorry, Simon.
Can we move SB 261 out of the block?
Okay. SB 26, did you say
261.
261 out of the block. All right, that one is removed from the block. Any other members wish to pull another bill from the block? All right. Clerk will please open the roll. On the block, the motion is to report the block and refer to appropriations. All members have voted. Clerk will please close the roll. Or the block is reported and referred to appropriations by a vote of 22-0. I got a motion on Senate Bill 261 by Stanley. Maldonado seconds to report and refer to appropriations. Clerk will please open the roll. All right, all members have voted. Clerk will please close the roll. Senate Bill 261 reports and refer to appropriations by a vote of 19-2. Chair Watts.
Thank you, Mr. Chairman. And now we have several bills that I will report individually. The first one is Senate Bill 18, and I move the line amendments.
Got a motion to adopt the amendment. Got a Maldonado seconds. All in favor say aye. Aye. Opposed? All right. Amendment's adopted.
As amended, the bill provides that if a child is younger than 11 is found to have committed an act that would be delinquent if committed by a child 11 years of age or older, The child shall not be proceeded upon as a delinquent, and the court shall dismiss any petition alleging such child has committed an act that would be delinquent if older. The order that the court records pertaining to such petition be expunged pursuant to relevant law, and the attorney for the Commonwealth, however, may file a petition alleging that such child is in need of services, and if such child is found in need of services, the court may make such any orders of disposition authorized pursuant to current law. It provides that any funding that is available to provide services to a child 11 or older who is proceeded upon as a delinquent shall also be made available to a child younger than 11 found to have been committed an act that would be delinquent. The bill adds the child may be taken into immediate custody when the child is alleged to be in need of services or supervision and there is a clear and substantial danger to the safety of the child's family or the safety of the public. Currently, a child may only be taken into immediate custody when the child is alleged to be in need of services or is in clear and substantial danger to their own life or health. Finally, the bill includes that the offense causing anyone that encourages or causes a child to be abused or to and willfully contribute to that child's an act that would be delinquent if committed if they were older, or causes any child to participate and to become a member of a criminal gang in violation of existing law shall be guilty of an offense of that offense. Under the bill, any person who commits such an offense is guilty of a Class 1 misdemeanor. Excuse my messing up. I move the subcommittee recommends reported as amended by a vote of 8-2, and I would so move.
All right, thank you. Got a motion to report and properly second Senate Bill 118 as amendment. Delegate Williams, you're recognized.
Mr. Chair, I had a question about one of the things we brought up in the subcommittee. There was an issue about converting the petition from like a delinquency to a chins. Did that get fixed or addressed at all?
Yes, it
She's
was.
shaking her
Again,
head yes.
These are lengthy explanations, and I was
Chair
trying
Watts.
to shorten it.
Chair Watts confirms that it was addressed. All right, any other members wish to seek recognition on the motion to report Senate Bill 18 as amended? All right, clerk will please open the roll. Clerk will please close the roll. All members have voted. Clerk, please close the roll. Senate Bill 18 reports as amended by a vote of 16-6. Chair Watts.
The next bill is Senate Bill 23, and it prohibits, there are no amendments. It prohibits plea agreements and court orders executed after July 1, 26 from containing any provisions that purports to waive, release, or extinguish a defendant's rights under the Fourth Amendment or the right to file a petition requesting expungement of the police records and the court records, or the right to have a criminal history record information and court records sealed. The bill provides that any such prohibited provision of a plea agreement or court order is void and unenforceable. The bill provides that such prohibition does not apply to plea agreements, written agreements, or court orders entered into as a condition for participation in the specialty docket or in a case involving a sexual offense where the victim is younger than 18. The bill further provides that any waiver, release, or extinguishment of rights under the Fourth Amendment shall be no longer than the period of supervised prohibition imposed against the defendant. If the defendant is not placed on supervised prohibition, it shall be no longer than the period of suspension of sentence imposed against the defendant. The subcommittee recommends reporting 7-3, and I would so move.
All right. We've got a motion and properly second to report Senate Bill 23. Any members wish to seek recognition on this bill? All right, seeing none, I ask the clerk, please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 23 reports by a vote of 15 to 7. Chair Watts.
Thank you, Mr. Chairman. The next bill is Senate Bill 137. I move the substitute.
Got a motion, all seconds to adopt a substitute. All in favor say aye. Aye. Opposed? All right, substitute is adopted. Senator Delegate Watts. Chair Watts.
Thank you, Madam.
It's okay.
Mr. Chairman. This deals with the obstruction of a healthcare facility. The substitute allows for a law enforcement officer to issue an order for any individual to withdraw from the premises if the individual interferes with access to or departure from the entrance or driveway to a reproductive health services facility. A violation of such order is a Class 3 misdemeanor and the first and second offense, and a Class 1 misdemeanor for a third or subsequent offense. The substitute also creates a Class 1 misdemeanor for any person not authorized by the healthcare facility who, by force or threat of force, by physical obstruction, intentionally injures, intimidates, or interferes with, or attempts to do so, another person because such other person is or has been, or in order to intimidate such person or other person or any class of persons from obtaining or providing reproductive health services, or intentionally damages or destroys or attempts to damage or destroy a facility because such facility provides reproductive health services. The substitute also provides civil penalties for any person who violates certain provisions in the bill in an amount not to exceed $10,000 for a nonviolent physical obstruction, $15,000 for a violent physical obstruction, $25,000 for subsequent violation. The substitute requires a reproductive health services facility to post signage to clearly mark the boundary for any person issued at court an order by law enforcement officer to remain behind should they be obstructing the access to the premise, to the facility. Such provisions are only effective 1 hour before, 1 hour after, and during business hours of the reproductive health service facility. Lastly, the substitute allows localities to adopt ordinance paralleling such provisions and establishes a civil cause of action for any person injured pursuant to a violation of such provisions, as well as injunctive relief. The subcommittee recommends reporting with substitute 7-3, and I would so move.
All right, got a motion properly second to report to substitute Senate Bill 137. Any members wish to seek recognition on this bill? All right, seeing none, I ask the clerk to please open the roll. Members, please cast your vote. All members have voted. Clerk will please close the roll. Senate Bill 137 reports with substitute by a vote of 15 to 7. Chair Watts.
Thank you. 2 more bills. Senate Bill 198, I move the line amendments.
Got a motion, Maldonado seconds to move to adopt the line amendments. All in favor say aye. Aye. Opposed? All right, those amendments are before us.
The bill prohibits admission of any evidence from an individual with developmental disabilities or intellectual disabilities in certain criminal prosecutions unless the court finds by preponderance of the evidence that such individual's decision to speak to law enforcement was not caused by and did not have a direct and substantial relationship to such individual's disability. The bill requires notice be given to the attorney for the Commonwealth if the defendant intends to introduce expert testimony regarding his disability, and it prohibits any statements made by a defendant during an examination by expert witness from being used against him except for impeachment or perjury. The subcommittee recommends reporting as amended and referring to appropriations 7-3, and I would so move.
Second.
Got a motion properly second to report the Senate Bill 198 as amended and refer to appropriations. Any members wish to seek recognition on this bill? All right, seeing none, ask the clerk to please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 198 reports and refers to appropriations by a vote of 15 to 7. Chair Watts.
Thank you. And the final bill is Senate Bill 230. I move the substitute.
Got a motion and Maldonado seconds to adopt the substitute. All in favor say aye. Aye. Opposed? All right, substitute's adopted. Chair Watts.
Senate Bill 230 makes a number of clarifications and changes in expungement of police and court records. It permits the expungement of records relating to an initial charge when a person is charged with the commission of an infraction, a crime, or a civil offense and is not ultimately convicted, provided that no stipulation of facts sufficient to find guilt was entered, or the court did not determine the facts sufficient to find guilt but deferred adjudication or disposition to a later date as a matter that would be eligible for expungement. The bill also permits that the petition made to request expungement of police and court records for multiple charges if all such charges arose out of a separate transactions or occurrences. The substitute also requires the attorney for the Commonwealth to include a factual basis for any objection filed to a petition for expungement. It allows any person who petitions for expungement and is the subject of an appeal to proceed under a pseudonym pursuant to relevant law. And it also provides that the existence of a prior conviction alone is not sufficient basis to deny an expungement. The substitute has a delayed effective date of December 2026. The subcommittee recommends reporting with substitute 9-1, and I would so move.
Second.
Got a motion and properly second to report Senate Bill 230 as substitute. Any members wish to seek recognition on this bill? All right, seeing none, I ask the clerk to please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 230 reports with substitute by a vote of 20 to 2. Chair Watts, that completes your report.
Yes, sir.
All right, I'll turn it over to Chair Simon for Civil Sub. Mr. Chair.
Thank you, Mr. Chairman. Let me start with our uncontested block. Actually, with the exception of Senate Bill 227, which I think we're going to need to pull out of the block because it's got some amendments. With that, I move the subcommittee amendments and substitutes for the rest of the block.
And a motion and properly second to adopt all the amendments and subcommittees substitutes in the block. It's got properly second. All in favor say aye.
Aye.
Opposed? All right, those are properly before us. Chair Simon.
All right, so Senate Bill 107 from Senator Pekarsky adds the list of persons who may be exempt from jury service upon request to those people that with legal custody and responsibility for the care of a child under 18 who has a serious health condition requiring continuous care during court hours, and the familial caretaker defined in the bill of a person with serious health condition requiring continuous care. Subcommittee recommended reporting, of course, 10 to 0. Senate Bill 189 is the next bill in the block from Senator Williams-Graves. Has to do with consumer debt collection proceedings. As amended by the subcommittee, the bill requires the attorney of record in any civil action to collect and enforce a consumer debt to include in the initial and pleading or any subsequent filing such attorney's full name, business address, and business telephone number. Next bill is Senate Bill 342 from Senator Perry. As amended by the subcommittee, this bill provides that if a person takes by condemnation any land subject to a conservation easement or open space easement, such person shall compensate the Commonwealth and the locality in which such land is located for certain tax credits and values enumerated in the bill. Bill specifies that any such compensation paid to the Commonwealth shall be in addition to compensation required by other provisions of law. Next bill was Senate Bill 660.
Did you want to wait until after he reports, or do you have something specific?
That is exactly what I was going to ask. We'll wait till after.
All right,
Okay.
we'll wait till after.
All right, Senate Bill 660 from Senator Rouse is the Virginia Self-Storage Act and creates a process by which the owner of a self-storage facility may dispose of personal property of an occupant of a leased storage space when such personal property has been left in such leased storage space on the property of the self-service storage facility following termination of a non-renewal agreement. So it just sets up a process to get rid of the stuff that they leave behind. You guys have seen this on Storage Wars. This is how we'll do it in Virginia now. Senate Bill 779 from Senator Obenshain has to do with eminent domain, and it provides the clerk of the circuit court will quickly and promptly disperse any just compensation specified in the order, and tells the clerk to go ahead and do that within no later than 7 business days after the entry of the order. Also provides that counsel in a condemnation action may request and the clerk, sheriff, or any other person responsible for notifying the jurors to appear in court for a trial shall make available a copy of the jury panel. So the subcommittee recommended reporting those bills unanimously, and I so move.
All right, got a motion properly second. Did you have a question, Delegate Williams, on the motion?
Well, on one of the bills in the packet.
Do you want to pull one of those out?
Yeah, well, I don't necessarily. I just want to ask her a question about it, but sure.
All right, so why don't we, I got a motion properly second to adopt those bills in the block. Delegate Williams, you're recognized.
Yeah, so obviously I wasn't on the subcommittee that discussed SB 342, and I was just curious. It looks like it's sort of like on the amendment, there seems to be a bifurcation of the cases now. Am I reading this correctly? It says
Yes.
shall be adjudicated separately from the determination.
Chair Simon.
Yeah, that's because we didn't want to conflate the issue of the just compensation that you get for the market value of the property that goes to the landowner, and then this is a separate issue of what the value of the easement it was to the locality or to the state. So these are conservation easements, right, where we agree, as a matter of policy, the Commonwealth agrees to forego the property taxes on it, devalues it, and so there's two different things. And so we wanted to bifurcate that process. So if there's the just compensation may be an easy call, but the locality may have a hang up with how much their version is worth, or vice versa. So we just want to make sure there are two different processes. The landowner wasn't getting caught up because the county was being slow to decide what they were willing to take.
Just a follow-up.
Delegate Williams.
So I understand you're separating the two different sort of parties that receive compensation type thing. Is it actually two different hearings at the same time, or could be two different hearings, or you're just separating the recovery?
Chair Simon.
I'm going to defer to counsel on that.
Ms. Olwine.
Mr. Chair, I don't believe it specifies. I think our understanding when we heard it in the subcommittee is that it would be two different hearings, though.
All right.
Thank you. That's my concern.
I see Delegate Kilgore.
Can we just remove that one from the block then? Just
Okay, we'll remove that. Any members want to move anything else from the block other than Senate Bill 342? All right, seeing none. 227's already been pulled from the block. That's right. All right. Clerk will please open the roll. Members, please cast your votes on the block. All right, clerk will please close the roll. The block reports by a vote of 22-0. Why don't we go back then to the Senator Perry bill, Senate Bill 342.
Move to report.
We had a motion, Maldonado seconds, to report Senate Bill 342 as amended. Any members wish to seek recognition on this bill? All right, clerk will please open the roll.
Destroy.
All right, so I'd ask the clerk to destroy the roll. We renew the motion to report 342, Senate Bill 342 as amended. All right, all members, please cast your votes. All right, clerk will please close the roll. Senate Bill 342 reports as amended by a vote of 15-7. Do you want to describe, Chair Simon, Senate Bill 227?
Sure. So Senate Bill 227, there are some new amendments that we had talked about in concept at the subcommittee, which I think the clerk has, go ahead, or the council has rather, but I'll sort of explain the bill first and we can do the amendments. And this requires a high volume arbitration service provider, which is, again, somebody who conducts more than 100 arbitrations in a year involving consumer, and any transaction agreement or dispute arises out of that, to establish and maintain certain procedures relating to the selection of the arbitrator. So under the bill, an aggrieved party by a high-volume arbitration service provider that's failed to comply with the requirements may seek injunctive relief or other appropriate civil remedies, or make application with the circuit court to vacate an arbitration award in accordance with the current law. The bill also requires all high-volume arbitration service providers to report information related to certain arbitrations annually to the State Corporation Commission, and permits the Commission to impose a $10,000 civil penalty per violation on high-volume arbitration service providers who fail to comply with the provisions of the bill. Finally, the bill provides that these provisions shall apply to arbitration agreements entered into on or after July 1st, 2026. So it's not retroactive in its application. And Council, you have some additional line amendments.
Ms. Olwine.
Yes, Mr. Chair, these were at the request of Senator Surabel. So there are 8 of them, and they're in front of all of you. The first one is on line 50. After purposes, we're striking or as an individual employed in the Commonwealth. The second one is at the beginning of line 56. We're striking consumer and a. The third one is on line 60. After dispute, we're inserting between a consumer and a business or between an individual employed in the Commonwealth and that individual's employer. The fourth is on line 66. After A, we're striking no, and we're inserting in any arbitration with a high-volume arbitration service provider pursuant to a pre-dispute arbitration agreement, the fifth one is on line 66. After shall, we're inserting not. The sixth one is on line 69 after parties. We're inserting in any arbitration agreement pursuant to a pre-dispute arbitration agreement. The seventh is on line 100 after an arbitration. Insert pursuant to a pre-dispute arbitration agreement and the last one is on line 100 after involving. We're striking the remainder of that line.
All right. Can I get a motion to adopt is it a substitute?
Move the amendments.
Move the amendments. All right. Got a motion and properly second to adopt the amendments. All in favor say aye.
Aye.
Opposed? All right. The bill is now properly before us.
So, Mr. Chairman, those amendments were, I think, things we talked about to try and narrow the scope to what the intended audience was. I think by having anybody employed in the Commonwealth, that was too many. We wanted to just get to disputes between the people and their employer. And we wanted to also restrict this to pre-dispute arbitration agreements. So these amendments effectively narrow the scope to what the patron was actually looking to do. And with that, Mr. Chairman, I would move that the bill report as amended.
I got a motion and properly second to report Senate Bill 227 as amended. Any members wish to seek recognition on this bill? All right. Seeing none, I'd ask the clerk to please open a roll. Clerk will please close the roll. Bill reports as amended by a vote of 22-0. Chair Simon.
All right. So thank you, Mr. Chairman. We've got a contested block now. 2 of those bills have been continued to 2027 already. So we're now at Senate Bill 536. And let me move, can I move the amendments and substitutes in this block as well, in a block?
Okay. Got a motion in Maldonado seconds to adopt all the substitutes and amendments in the block. All in favor say aye.
Aye.
Opposed? All right. Those bills are before us.
All right, so Senate Bill 536 from Senator Obenshain. That's going to go by for the day. Can I move that? Yeah, I guess I need to, we talked, you announced at the top. I move that Senate Bill 536 go by for the day.
Second. All in favor say aye.
Aye.
Opposed? All right. That bill is by for the day.
All right, so the first 3 bills were taken care of. All right, Senate Bill 540 is also from Senator Obenshain, and this has to do with undue influence on trusts. And the bill as amended with the substitute provides that an action contesting the validity of a trust or trust agreement where a presumption of undue influence arises, the fact finder shall presume that the undue influence was exerted over the decedent unless evidence leads the fact finder to determine the decedent did not intend for the real or personal property to be conveyed or transferred as indicated. Current law applies to the presumption of undue influence only under actions contesting the validity of a will. Subcommittee recommended reporting with substitute by a vote of 6-4, and I so move.
Got a motion and properly second to report Senate Bill 540. Any members wish to seek recognition on this bill? All right. Clerk will please open a roll. All members have voted. Clerk will please close the roll. Senate Bill 540 reports with a substitute by a vote of 15-6. Chair Simon. Delegate Kilgore.
Mr. Chairman, what happened to 376 Survey?
That was continued to 2027.
Thank you.
All right, Senate Bill 725. Actually, I moved the substitute. We didn't have a substitute before. All right, so Senate Bill 725, there's a new substitute that's before the committee today. What the bill does, it keeps the entire delegate, it keeps Senator Jones' bill completely intact, and it adds to Senator Jones' bill most of the contents and substance of my House Bill 448, which also had to do with clerks of court and recording fees and things that could be recorded. My hope is that by sending both those over together on Senator Jones' bill, we might get some progress on some of the things I was looking for in my bill. And so I would move the committee substitute.
Second.
Got a motion and properly second to adopt the substitute. All in favor, say aye.
Aye.
Opposed? All right, substitute's approved.
Okay, and so the bill, the new part of the bill, again, by House Bill 448, we passed unanimously out of this committee and off the floor, so there's nothing in that part of the substitute that we haven't seen voted on previously. What the rest of the bill does is it increases the technology trust fund fee that clerks charge from $5 to $8, and increases another fee from $4 to $6, and it actually doesn't say, the title says 5 to 8, but I'm just not sure what it does, to be honest with you. Hold on, I got to see these two different sets of numbers here. Counsel, can you help me out with this? I'm sorry.
No, that's okay, Mr. Chair. There are a couple of different fees that are increasing. So it increases the technology trust fund fee from $5 to $8. It increases the amount of the fee to be allocated for one of the purposes from $4 to $6, and then it authorizes the remaining $2 of that fee to be allocated to individual circuit court clerks' offices for one of the purposes as described in the bill.
All right, so that's an amendment we want to adopt?
Yep.
Okay, got a motion?
And so with that, the subcommittee recommended reporting 8-1 over my objection, but with the new substitute, I now would change my vote, and I'm going to move that we pass this bill.
Okay. So is that the substitute Ms. Owen just read, so we got to adopt?
No, she was reading the underlying bill.
Okay.
And the substitute was House Bill 448, which puts the two things together. So the bill does both things. The things that Owen described in my bill that we all passed unanimously.
Okay, so we got a motion to report 725 with a substitute. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 725 reports with substitute by a vote of 21-1. Chair Simon.
All right, next we have Senate Bill 753 from Senator Reeds, which expands the existing ability of any person to maintain a suit in equity, including the accompanying remedies available and statute of limitations for the unauthorized use of his name, portrait, or picture for advertising purposes or the purposes of trade, to include the unauthorized use of his voice or likeness. Subcommittee recommended reporting and referring to the Committee on Communications Technology and Innovation by a vote of 8-1, and I so move.
Got a motion and properly second to report Senate Bill 753 and referring to Communications Technology and Innovation. Any members wish to seek recognition on this bill? All right, seeing none, clerk will please open roll. All members have voted. Clerk will please close the roll. Senate Bill 753 reports and refers to CTI by a vote of 22-0. Chair Simon.
And finally, Mr. Chair, my last bill is Senate Bill 794 from Senator Perry, which establishes the Virginia Healthcare Protection Act. The bill provides that no law enforcement officer acting in the Commonwealth or employed by the Commonwealth or any of its localities or political subdivisions may investigate, arrest, or detain any person, seek the issuance of a warrant, or otherwise assist in or provide support for any investigation involving protected healthcare activity as defined in the bill. The bill creates a private right of action for any person who is aggrieved by such unlawful investigation to obtain an injunction or other equitable relief against such law enforcement officer. The bill also creates a private right of action for any person who sustains any injury, damages, or other harm resulting from another person who, under the laws of a jurisdiction other than the Commonwealth, engages or attempts to engage in abusive litigation as defined in the bill, and also provides that no demand for extradition of a person charged with a criminal violation of a law of another state shall be recognized by the governor if such alleged violation involves protected healthcare activity within the Commonwealth, unless the alleged criminal violation would also constitute a criminal offense under the laws of the Commonwealth. Finally, the bill provides that any subpoena under the Uniform Interstate Depositions and Discovery Act or any summons for a witness or other state for another state in a criminal case shall include an attestation made under penalty of perjury stating whether the subpoena or summons seeks documents, information, or testimony related to protected healthcare activity. Subcommittee recommended reporting by a vote of 7 and referring to appropriations by a vote of 7-3, and I so move.
A motion and properly second to report Senate Bill 794 and refer to appropriations. Any members wish to seek recognition on this bill? All right, seeing none, I ask the clerk to please open roll. Clerk will please close the roll. Senate Bill 794 reports and refers to appropriations by a vote of 15-7. Thank you very much, Chair Simon. Is the Senate close? All right, so why don't we have the committee go at ease? We do have one bill that we want to hear, in its entirety by Senator Marsden. And so since they are wrapping up, we're going to go at ease for a few minutes to get him over here and hear that bill. So committee will be at ease. back in session. We have Senate Bill 622. Senator Marsden, it's great to see you. You have a bill that you'd like to present?
I do, Mr. Chairman. I also have 40 bills waiting for me in Commerce. So if we can stretch this out for about an hour and a half.
All right, then we will go at ease
That
and
would
come
be
back
good.
around 5.
Okay.
Senator, you're recognized.
All right. Are you ready?
Yes, sir.
All right. This bill establishes a published rate framework for title insurance in Virginia. It requires everyone to adhere to the policy rates which are filed with the State Corporation Commission's Bureau of Insurance. The legislation aligns Virginia with more than 40 other states who operate under some form of published rate framework. The substitute before you, this was, of course, what is now this bill, preserves the ability for negotiation for residential with the agreement of the insurance company, ensuring flexibility within a transparent regulatory structure. Senate Bill 622 addresses a real point of confusion and frustration for Virginia homebuyers. For many families across the Commonwealth, closing day is one of the largest financial moments of their lives, which is why we need better transparency regarding title premium pricing. Under current law, the title insurance rates are provided to the State Corporation Commission by each title insurer, but there is no statutory requirement that the same be adhered to by any party issuing a title policy. This leads to pricing uncertainty, limited transparency, and disparities in what different consumers pay for the same product and the same risk. Individual home buyers typically lack both the information and negotiating leverage available to larger purchasers, which can place them at a structural disadvantage. Senate Bill 622 will provide price predictability for consumers, support more accurate loan estimates and settlement disclosures, and enhance responsible regulatory oversight by reducing ambiguity around permissible pricing. SB 622 also helps prevent hidden inducements and promotes more consistent treatment across consumer classes. Importantly, 622 aligns title insurance with regulatory framework already used in other lines of insurance, strengthening consumer protection while preserving a competitive marketplace. Virginia currently is an outlier. More than 40 states already operate under some form of a published and filed rate framework for title insurance, including all of Virginia's neighbors. The 4 title insurance companies are all in support of this legislation. For these reasons, I would like to ask that you report this bill and here for any questions.
Thank you, Senator. Thank you very much. Any members have any questions for the patron at this time? All right, seeing none. Anyone here to speak in favor of Senate Bill 622? Can I ask you to please line up? Come on up. Is it just the two of you?
Yes, sir.
Okay. So why don't we put 5 minutes on the clock?
Mr. Chairman, members of the committee, thank you for your time today. My name is Joe Shepard, and I am the state manager for the Fidelity family of companies here in the Mid-Atlantic. That includes the Commonwealth of Virginia, the state of Maryland, the District of Columbia, and West Virginia. At its core, Senate Bill 622 is a consumer protection and industry health bill. Currently, the consumer in Virginia bears a disproportionate burden in the title insurance market, meaning the individual residential consumer pays more at a price per thousand for their title insurance coverage than does a commercial client. This bill eliminates that. For the 5-year period, or for the 7-year period between 2019 and 2025, the Virginia residential consumer paid roughly, on average, $3.86 per $1,000 of coverage for their title insurance. The commercial consumer paid $1.06 per $1,000 for their title insurance coverage. That is a huge disparity. This bill is also a health of the industry legislation. 10 years ago, I probably would not have been standing here in front of you. 10 years ago, 15 years ago, a $50 million transaction in the Commonwealth of Virginia was a huge office building, a huge shopping complex. Today, we are being asked to insure $3 billion with a B data centers or other huge mega transactions. And to do those transactions at $1 per thousand or less in many instances is just not sustainable for the industry. Many of you are probably familiar with, or at least tangentially are aware of, Southern Title Insurance Corporation, which was a Richmond-based title insurance underwriter that in 2014 went under because they were not adequately capitalized, and their claims loss out of the state of Texas took them under. We don't want that for the title industry. That is not a good result. So this bill helps to ensure that title underwriters are being compensated appropriately for the risk that they are assuming. Secondly, this bill, as Senator Marsden already indicated, adds predictability and transparency to the title industry. If a title insurance underwriter must charge the rates which it publishes, then the Virginia consumer knows exactly what they're going to pay for their title insurance when they go to work with a settlement company or a title insurance agent. And still, within the framework of our existing published title insurance rates, consumers, both residential and commercial, are already entitled to certain discounts based on the age of their policy, how long they've been in the property, different factors like that. So there are already opportunities to pay discounted rates. And we've done the actuarial data to indicate that those discounted rates are in fact appropriate. So again, I would ask that you report favorably on this bill for both the Virginia consumer as well as the title insurance industry. Thank you.
Hi, I'm Catherine Crawford, and I am State Counsel for First American Title. And I agree with everything that my colleague, Mr. Shepard, has said. We are both here to advocate for the health of our industry, and it's something that we take very seriously. But we also want to be sure that we are protecting Virginia consumers. And by asking for a regulatory framework that is very similar to what we have in the other insurance lines, we are taking a very positive step to make sure that we are ensuring the health of our industry. So I'm not going to reiterate a lot of the facts that Mr. Shepard said, but I'm happy to answer any questions that anyone has.
Can I ask, how do other states handle this area?
Sure. So there are probably about 5 different frameworks. Some are considered publish and use rates, which is what we're asking for here in Virginia. So each title insurer, through their own research and claims history, comes up with the appropriate rates, and then they publish those to a regulatory body, and then they are required to adhere to those. Some have file and use rates, which give the regulatory body the ability to say yay or nay, we agree with these rates or not. Some also have private groups that agree on a rate, and everyone who is a member of that group has to agree on those rates. So it does vary from state to state, but over 40 states have some regulatory framework. So we really are lacking in that area in the Commonwealth.
That's helpful context. All right, Delegate Simon, you're recognized.
Yeah, so I don't know if this is necessarily a question for anybody. I do want to push back a little bit on this dollar per thousand statistic we've got, because you guys, the way that title insurance is priced, just so you know, already is it's at a graduated rate. You pay the highest premium on the first $100,000, then you pay another premium that goes, it steps down from 100 to 500 and further it goes, right? So obviously commercial deals, which have enormous amounts of money, are going to have a lower cost per thousand than somebody's buying a $150,000, $250,000 condominium, because they're always going to be paying just the highest per thousand rate. I have a different theory, and Catherine and Joe and Senator Marsden both know my theory about why title insurance rates have gone up over the last decade or so. I don't think it has anything to do with this. My theory in being in the business is it has to do with the proliferation of controlled business arrangements where real estate agents and other referral sources control the business, and most folks go into a transaction not knowing that they have any leverage or any opportunity to talk about a discount on their title insurance because the referral source, which is usually not the title insurance person but the realtor or a bank lender, tells them they can't negotiate it because they're monetarily incentivized not to do that. So if you want to have a comprehensive conversation about what's driving up the cost for consumers of title insurance, I welcome a conversation like that. But essentially what I'm hearing this bill does, and this model that you all have picked, says we want to tell you, SEC, what our rates are going to be, and then we want you to tell us we're not allowed to go below them so that we can turn around to our customers and say, hey, listen, we'd love to help you out. We wish we could, but the state won't let us discount the rate. And that seems like a pretty good way to do business. I get why you want that. I would love to be able to say, hey, this is my hourly rate, and all you clients can't ask me to discount it because the state won't let me do it. I don't think this is a good model for consumers. I understand the concerns of the industry. I do, and I'll say one last thing about this, and I'll be in trouble with both of you guys, because usually these guys are whining and dining me trying to get my business. But in this case, I'm on the other side of the dais. To see, frankly, two of the biggest competitors in this business saying we want the same deal could tell you one of two things. But to me, it tells me that they're tired of having to compete with each other. I mean, you guys could get around this problem of charging this race to the bottom on commercial deals by negotiating harder and being better. But the problem is, if you guys say no, one of y'all is going to say yes, and you're going to have to keep going downward. So I think that this is, I get your concern. I don't know that this is the best solution. I don't know this is the best way to use state power to prevent folks from negotiating. So I'm going to be a no on this bill. Thank you, Mr. Chairman.
All right. Thank you, Delegate Simon. Delegate Keys-Gamarra, you are recognized.
Thank you, Mr. Chair. I do not handle this kind of thing, so the question I'm asking has to do with clarification. Mr. Chair, in the event that there was, let's say there was a consumer watch group watching what has happened with these rates, and they note that perhaps a particular sector of a community is paying higher rates as opposed to someone similarly situated on a different part of town, would there be any kinds of recourse for that group of consumers under your scheme? I'm sorry, arrangement.
Sure. So the current framework, which would not be touched at all, already requires the rates to be reasonable and non-discriminatory. So that does not change. And currently, the title insurance is very different from other types of insurance. There is no underwriting of whether the policyholder is one that we want to insure. It is the property. It has nothing to do with the actual insured. So that's why we are very different from other lines of insurance. So by de facto, it's the property, not the insured, that matters.
Follow up, Mr. Chair?
Delegate Keys-Gamarra. Yes.
Typically, properties are located within certain communities with certain individuals. And scheme was a slip. It was not, I was not trying to be sarcastic.
Okay.
So in the event that, I think while the law may say you can't discriminate, let's say there is an allegation that there is some discrimination, is there recourse?
Sure. A complaint can be filed with the Bureau of Insurance, and then they are obligated to then open up an investigation and determine whether that in fact happened. But even as a title insurer, we just see a property report that says, here's the deeds, here are any liens on the property, and then we proceed to insure. So it would be very hard to think of a case where any, actual discriminatory actions are being undertaken by folks issuing policies, since it is just the property itself. So, yes, absolutely.
Delegate, as further explanation, when a title insurance underwriter publishes its rates with the Bureau, those rates are set for property anywhere in the Commonwealth. It doesn't matter property location, property type, it is just based on the amount of risk that we as an underwriter are assuming. So the graduated premium schedules are all based on dollar purchase price of the property, if that adds any flavor or any color for you.
Thank you very much. Any other questions for the patron or these witnesses here for the pro? Because I haven't heard from the con yet, and so I just want to make sure. But if there's any questions, Delegate Williams, you're recognized.
Yeah. So is it just because of how much investment is being placed on the land that is like skyrocketing your risk? Is that the issue?
So the risk increases as the amount of insurance increase. The amount of insurance is based on, for an owner, the amount that they are purchasing the property for. For a lender, it is the amount that they are lending on the property. Right. So that, of course, is increasing just because all home values are increasing and loan amounts are increasing. And also, as Mr. Shepard alluded to, the commercial deals are so much larger in today's economy than they were even 10 years ago.
All right, thank you very much. All right, seeing no other questions, why don't we listen to see if there's anyone here in opposition to the bill, Senate Bill 622.
Good afternoon, Mr. Chairman, members of the committee. I'm Phil Abraham, represent the Virginia Association for Commercial Real Estate. We are commercial industrial developers in Northern Virginia, Hampton Roads, and the greater Richmond regions of Virginia. We do strongly oppose this legislation. We did not testify on it in the House. I have to say it didn't come to our attention until after it crossed over. While it's a good talking point that this legislation will somehow reduce title insurance rates for single-family homeowners, there's no evidence that negotiation of commercial rates, as is currently the case in Virginia, impacts residential rates, or that prohibiting negotiation for commercial rates will somehow reduce the rates for single-family homeowners. Commercial and residential rates are distinct markets with separate risk assessments, separate pricing structures, separate underwriting, and separate management. Commercial rates are higher based on the dollar amount of the deals, as Delegate Simon explained. They're much more complicated, and they're much less cookie cutter. You have everything from a 7-Eleven to a large factory. You have residential properties on a single parcel. You have a commercial property that might bring together a whole number of parcels. It requires much more work. As Delegate Simon said, while the numbers that were presented show a lower dollar per thousand, given that the commercial properties are much more expensive, our rates, we end up paying much more on a deal than a residence would. $1 million commercial deal is $10,000 worth of title insurance. You have two insurers here today. There are 4 big title insurers in the country, so 2 of them aren't even here asking for this. The state association isn't here asking for this. The proponents are asking you to believe that you should increase costs for the more expensive and complex class of insurance with the hope and promise they will somehow reduce residential rates that are less profitable and have tighter margins. Residential rates are set nationally. Commercial rates are set more locally. Residential rates are typically 0.5% to 1% on the sales price of the property. Commercial rates are set much more complex based on the particulars of the deal or property in front of you. I'll also emphasize that commercial includes multifamily housing. So while even if what they say, they might reduce residential single-family home title insurance rates, the title insurance rates for all multifamily dwellings that are built in Virginia will go up under this bill. At the same time, they're asking you to trust the fact that they will lower residential rates with this legislation. They ask that they simply be allowed to publish their rates and hand them to the state corporation. There's no prior review of these rates. We don't know when the State Corporation Commission will look at them. At the same time, they propose to increase commercial rates and prohibit negotiation. They're adding language. The most language in this bill is in Section B, which tells you the instances where they can charge rates in excess of their published rates. While there is a carve-out for allowing residential rates to be negotiated, residential rates are almost never negotiated. It's a meaningless carve-out, but what it does do at lines 45 through 50, it exempts the residential policies from all the other protections in the bill. The U.S. Department of the Treasury conducted a roundtable on the title insurance industry and analyzed potential reforms in July 2024. In its report on that meeting, it said, and I quote, "Academics and other participants stressed the importance of obtaining quantitative data and conducting independent research to ensure that any discussion of potential reforms are grounded in data-driven analysis." I submit you don't have that data, and you should not support this bill. I appreciate your consideration. Thank you.
All right, any other members wish to seek recognition on the bill? Questions for the patron? All right, seeing none. Senator
Mr.
Marsden.
Chairman, I think if we could have a quick rebuttal on
Of course,
some of that.
Senator
Thank you.
Marsden, yeah.
Just wanted to correct a couple of mistakes in the last speaker's opposition. All of the title insurers in Virginia were brought together, and this was discussed. So we are just two representatives from the different title insurance companies, but all of them were in favor of pursuing this legislation. So I did want to point out that one key fact.
Thank you for that. Any other members? Okay, so Senator Marsden, did you want to have a last word or?
Well, I think, obviously residential folks in a situation where you're publishing your rates, I think you're trying to keep them low, you're trying to be competitive and what have you, as opposed to taking advantage of a homeowner by, giving him a higher rate than may be required. And that because homeowners, when you're going in to settle on a home, they're telling you, this is going to be over 30 years, you're going to be paying for this, and so you go, okay, I'll sign.
Right.
And but the commercial folks, they know what they're doing, into the negotiating process, and they know what rates ought to be and what have you. So I think there's a real attempt here, to try to protect residential customers.
All right, thank you, Senator. Thank you for bringing the bill forward. All right, the committee works on motion.
Mr. Chairman.
Yeah.
Mr. Chairman, I appreciate the concern about the rising rates. I don't know that this bill solves it, but I do know, I get the sense from some of my colleagues that they'd like to learn more about the issue. Mr. Chair, I would move that we lay the bill gently on the table with a letter from you asking the Bureau of Insurance to look at this issue and see what we can do within the legal framework to bring with a goal of bringing costs down for consumers.
I'd be glad to do that if that works for the committee. Got a motion to lay the bill on the table with a letter from the chair to the Bureau of Insurance to ask if they come back with some recommendations on this investigate. Anyone have any okay with that motion? Second. I got a motion and properly second to lay the bill on the table. That is non-debatable. Clerk will please open the roll. All members have voted. Clerk will please close the roll. Senate Bill 622 is tabled by a vote of 14-4. Senator Marsden, let's get together and put a letter together.
We'll put a letter together for you. Thank you, Mr. Chairman, members of the committee.
Thank you. Thank you all very much. All right, that's the docket for the day. The committee shall rise. Oh, by the way, before everyone goes, just to sort of give you a landscape for the rest of the week, this is our last week to take action. There may or may not be a bill that comes forward on Wednesday. We're waiting to see if that happens. Friday is definitely going to be a day that we meet for judicial interviews. I'd like to see as many people here as possible. We need a quorum because I'd really like to, after the completion of the interviews, is to certify the nominees so that we can send their nominations to the floor for the following week. So just want to make sure you're aware. As soon as I find out about the schedule on Wednesday, I will, of course, let you know.
How many judicial candidates?
About 15, 20. How many judges? About 15 or 20, Shannon? 20. 6, 7, 6, 7.
That's a big difference.
All right.
All right.
Wishful thinking.
I'm just asking for the plan.
Yeah, okay, I got you. So please try to make every effort to attend the interviews. All right, with that, committee will rise.